Today, the Supreme Court heard arguments in the Trump ballot case. The highest court in the land now set to decide whether former President Trump is disqualified from seeking office.
The justices will determine whether Colorado's top court was correct in applying a post-Civil War provision of the Constitution to order Trump off the ballot. The Colorado court reached that conclusion after his actions around the January 6th attack on the U.S. Capitol amounted to insurrection. CBN White House correspondent Abigail Robertson is at the court. Abigail.
Well, John, after today's hearings, the Supreme Court could really decide at any time whether the insurrection provision in the Constitution disqualifies former President Trump from the ballot.
The Colorado Supreme Court's decision is wrong and should be reversed.
Trump's lawyers argue January 6th was an unorganized riot, not a planned insurrection.
This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection.
Jason Murray, the plaintiff's attorney, disagreed, arguing the former president did indeed commit insurrection and specifically addressed the 14th Amendment as precedent.
Well, what they were concerned most about was ensuring that insurrectionists and rebels don't hold office. And I would note that if President Trump were appointed to an office today, if he were appointed as a state judge, he could not hold that office.
Throughout the arguments, all 9 justices appeared skeptical of whether or not states have the authority to remove Trump from the ballot under the 14th Amendment.
I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me.
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation.
Many legal experts predict the Supreme Court seems unlikely to rule in favor of Colorado keeping Trump off the ballot.
A state cannot exclude any candidate for federal office from the ballot on account of Section 3. And any state that does so is violating the holding of term limits by altering the Constitution's qualifications for federal office.
President Trump says he's leaving his fate up to the justices.
An argument that is very important is the fact that you're leading in every race, you're leading in every state, you're leading in the country against both Republican and Democrat. And Biden, you're leading in the country by a lot. And can you take the person that's leading everywhere and say, hey, we're not going to let you run? I think that's pretty tough to do, but I'm leaving it up to the Supreme Court.
With the Colorado GOP primary set for March 5th, it is likely we will see an expedited decision from the Supreme Court within a few weeks. John, Jenna.
All right, CBN White House correspondent Abigail Robertson. Thank you, Abby. Well, John Malcolm is the vice president of the Institute for Constitutional Government and director of the Meese Center and the Simon Center at the Heritage Foundation. He joins us now for some legal analysis. John, welcome to you. So the justices' questions seem to lean in favor of former President Trump. Twofold question. What were your takeaways? And maybe if you can just back us up a little bit and remind us of how we got here with this particular case.
Well, we got here because a bunch of people who want to bounce Donald Trump from the ballot filed a lawsuit claiming that he was an insurrectionist who had previously taken an oath to support the Constitution, and as such, he was disqualified from holding the office of the presidency under Section 3 of the 14th Amendment. And they also argued that the states could make this decision without any implementing legislation from Congress, that it was up to each state to make that determination using whatever process existed in state law. I think today was a very good day for former President Trump. It's always perilous guessing from the arguments how a case is going to come out, but I think it's pretty clear that there are at least 5 justices to overturn the Colorado Supreme Court's decision, and it in fact would not shock me if it was a unanimous decision. There are a number of different grounds that they could rely upon, the chief ones being that he is not an officer of the United States. A president is not an officer of the United States under the 14th Amendment, Section 3. Also, that that provision is not self-executing and requires a federal legislation to decide the procedures for deciding whether to bounce somebody off of the ballot. Such legislation does not exist at the moment. And you heard in the question from Justice Kagan, and a lot of the other justices asked this question about how can it be that each state, using whatever processes they deem appropriate, make a determination about who qualifies and doesn't qualify to be on the ballot, particularly when the thrust of the 14th Amendment was to give the federal government more power, not the former Confederate states, leaving it up to them to decide who qualifies and who doesn't qualify.
To your point, Chief Justice John Roberts suggested that if the court ruled in favor of Colorado, elections could be left up to just a handful of states. He also said it could lead to some states removing the Republican nominee, other states removing the Democratic nominee off of ballots. John, your thoughts on that and the court really seeming to want to leave the power in the hands of voters?
It would be a complete mess if it was left up to each state. And I think that was patently obvious to all of the justices. The response they got was just trust the system to work itself out. And if there are really any major problems, you can review these on a case-by-case basis. I do not think the justices found that very satisfying at all.
About a minute left here, John. Could you see a situation in which the Supreme Court maybe issues a limited ruling just for Colorado and not other states?
Yeah, they could, but I don't think they're going to. They could say, yes, the states can do this, but the process that Donald Trump received was too truncated to satisfy due process of law elements. They could also say, well, you know, that section disqualifies someone from holding the office. It doesn't prevent anyone from running for the office. So we'll kick this can down the road. They might do the second one, but I doubt it. I think that they want to resolve this issue and not have it come back up again at a time when it could even engender more chaos.
Yeah. All right, John Malcolm with the Heritage Foundation. John, always good to see you. Thank you so much.
My pleasure.